Hi everyone, my name is Charity Clark. I am a criminal defense attorney here in Arizona, and I'm doing some videos on Proposition 207 that recently passed here in Arizona. That is the proposition that legalized recreational marijuana. Previously, we only had marijuana usage for medical marijuana use. I've done 2 videos already, so please go check those out. Those videos are related to why this proposition is really helpful to everyone, regardless of your position on consuming or using marijuana. It does actually benefit everyone. Additionally, the second one was about what is legal. What can you actually possess? What can you actually have? That's really important as well. Please go review that one. That one is going to be really helpful for further understanding what we're going to talk about here. But here we're going to talk about primarily what's not legal and what the penalties are should you wind up stepping outside of the protections of Prop 207, how that can affect you. So first, let's start with a quick recap. What is legal is 1 ounce of usable marijuana for possession, no more than 5 grams of which is a concentrate of marijuana. That's important to make sure you're aware of. A concentrate in Arizona, and most people are shocked when I explain this, concentrate in Arizona of THC, in other words, edibles, what you have in your pen when you smoke out of a pen, that is considered a narcotic drug. So that's a higher class of drug and therefore a higher class of felony if you are using it or possessing it illegally. So you want to be careful of that. Additionally, you can own up to 6 plants. You will have to be over 21 to legally possess marijuana in consumption form or in plant form. As far as the plants go and the cultivating it, there are some real restrictions on what you can do there. Please check that out in my other video so that you can understand, if you plan on growing, what that means. If you are under the age of 21 and you are caught possessing or consuming or transporting 1 ounce or less of usable marijuana or 5 grams or less of concentrate, you are guilty of, for your first offense, a civil violation. So that's like a ticket. It's like getting a traffic ticket. The penalty there is no more than $100, and you can be ordered to attend up to 4 hours of drug education classes. Your second violation is a petty offense. A petty offense is a criminal offense, but it's the lowest level of criminal offense. In fact, it's very rarely even charged in Arizona. We have very few petty offenses that actually come across my desk. But for a petty offense, for this possession of marijuana under the age of 21, you can be ordered to attend up to 8 hours of drug education. If you are caught for your third or subsequent time, then you are looking at a Class 1 misdemeanor. Class 1 misdemeanor is the highest level of misdemeanor that we have in Arizona. Right above Class 1 misdemeanor is your Class 6 felony, lowest level of felony. Now, what's really important for you to understand here is if you are under 21 and you possess more than 1 ounce, or you possess more than 5 grams of a concentrate, you're no longer under what is the offense here in Prop 207. That would then remove you into Title 13 for the criminal offenses for possession of marijuana and possession of a narcotic drug. Once you get there, you're looking at felony counts. So some of this is still in the works. We're still talking about what can and cannot be done here. There's some things that are ambiguous, but as of right now, that's where we're at with this. So if you're under 21, you could be looking at really serious offenses if you step outside of what is talked about here. Additionally, if you are over 21 and you are possessing more than 1 ounce, but no more than 2.5 ounces of usable marijuana, and you are possessing no more than 12.5 grams of the concentrate, but more than 5 grams, you're looking at a petty offense. So again, important to note is this only applies to between 1 ounce and 2.5 ounces. So you're fine over 21 with 1 ounce. You go over 1 ounce, you are now looking at a petty offense. You go over 2.5 ounces, you are outside of Prop 207, and you are looking at prosecution under the Title 13 and the felony statutes that we have there. Similarly, if you have 5 grams and you're over 21, you're okay. You go over 5 grams and you're under 12.5 grams, you're looking at a petty offense. You go over 12.5 grams, 13 grams, you're now outside of Prop 207 and you're looking at prosecution under Title 13. And those are serious felony offenses. Next, if you're over 21, you're legally possessing, you don't have more than you're supposed to possess. You can only consume it in private areas. You cannot consume this in any public or open space. If you do, for your first offense, it's a petty offense. If you do this more than once, your second or subsequent offense is now a Class 3 misdemeanor, which is the lowest class of misdemeanor in the state of Arizona, but still a criminal offense and slightly higher than a petty offense. If you're under 21 and you lie, misrepresent, provide a false ID to get marijuana, you are guilty for your first offense of a petty offense. If you do it more than once, so second, third, fourth, fifth time, you're guilty of a Class 1 misdemeanor. If you're under 21 and you just solicit to purchase marijuana or a marijuana product, so you don't actually buy it, you don't provide a false ID, maybe you don't lie about being under 21 and you try and get marijuana, you are guilty of a petty offense for your first offense and a Class 3 misdemeanor for your second and subsequent offense. Now, here's something we talked about in one of the other videos, is the delivery of marijuana, and this is something I've had some questions about. Again, I can't cover everything. Please feel free to contact me, ask me some questions. I may do another video that goes over the questions that I get, because there's just so much that can come up that I can't get to all of it. But if you are delivering marijuana, you need to be, the way I'm reading this, how it's written at this point in time, you need to be a marijuana establishment. The marijuana establishments are going to be regulated by the Department of Health. The Department of Health has until January to start coming up with rules and regulations for that. So when you've been hearing about this isn't in effect until January, they're talking about what the Department of Health needs to get done. We don't know what the rules and regulations the Department of Health are going to do as of yet. So when the Department of Health comes up with that, it's talking about marijuana establishments and what they need to have, and you have to apply for that, similar to a liquor license. If a marijuana establishment is delivering marijuana not within what's been established by the Department of Health, they are guilty of a civil penalty of $20,000 for each violation. Now, the way that I'm reading this, the way that it's written right now, I don't think, if you are not a marijuana establishment, I don't think this protects you. And then you're just guilty of a $20,000 fine. If you are delivering marijuana, I think you wind up looking at sales and transportation violations under Title 13. That are serious felony offenses. So that's something that we dealt with the Medical Marijuana Act, where people were trying to deliver. Again, watch my other video, it'll give you a little more information on that, but then they were facing some serious felony charges. So that is what we have right now for delivery. Don't think you can use this as a way currently to just start up your own business. There's going to be some regulations on it that are very strict and strenuous. You need to go make sure you comply with those, because if you don't comply with them, it's not just a slap on the wrist. It's not just a civil penalty. You could be looking at serious felony offenses. So those are the things related to the illegal aspect of marijuana still. One good thing related to that came out of this is expungement. In Arizona, we have never had an expungement statute. We have our first expungement statute. If you have ever been arrested, prosecuted, or convicted of possessing marijuana that would be legal under Prop 207, you can now have that record expunged. That would order anyone who arrested you or was in the process of that investigation to seal those records, the prosecuting agency to seal the record, the court to seal the record. So all of that would be sealed. You would be the only person to have access to it. I believe this process is going to be pretty similar to what we've done with a petition for innocence, which is a petition that you can do if you were ever arrested illegally. You can do that to seal your record. So that's what we have here with Prop 207. Again, there's still some things there that are being figured out and being determined. But if you have ever had that kind of an arrest, that kind of prosecution, or that conviction, or you're curious as to whether or not you comply with this, please feel free to contact me. I will be happy to assist you in that and go through what can be done there. So these are just kind of some basic, quick rules as to what's allowed, what's not allowed. Again, feel free to contact me if you have questions. Be careful not to try and step outside of it or stretch it. Get legal advice before you do anything with marijuana so that you're ensuring that you're not violating anything here. Stay tuned. Look for the next video. I'm going to be talking a bit about DUIs and the change on marijuana DUIs.